Ladies and gentlemen, my name is, as Ivan said, Bartłomiej Oręziak. I hold a PhD in law and I'm an assistant professor at the Faculty of Law at the Kardynał Stefan Wyszyński University in Warsaw. I'm also a member of the Polish-Hungarian Professors Network for the years 2025-2026. I would like to sincerely thank organizers of today's conference, Central European Academy University of Miskolc and John Paul II Catholic University of Lublin. You made a great work and thank you very much for the invitation. Within this great network, I take part in the research group entitled Accountability of Constitutional State Organs in the Context of a Rule of Law Crisis, led by Professor Marcin Wierec. Our research focuses on the responsibility of constitutional bodies, constitutional state organs, in situation of a rule of law crisis. And in my case, I took and look at this problem mainly from the perspective of international and European law. It is a great honor for me to take part in this conference and share with you some of my reflection within this research framework. So, ladies and gentlemen, as you can see at the slide, the title of my presentation is From Safeguard to Justification. This is the process and the instrumental use of international and European law in the Poland's rule of law debate. So, for the purpose of this presentation, I start with a basic assumption about the relationship between domestic and international law and European law. This assumption is grounded not only in history and literature, but also in the very nature of the state and the main decision subject of international law. International law and European Union law, as it is a part of it, has a secondary character in relation to domestic law. It is states acting within the constitutional orders that create international law and define the scope of competences they decided to transfer. This transfer, in my opinion, should be partial. Why? Because it reflects the sovereignty of state and is limited by the key principle, like as the principle of conferral, principle of subsidiarity, principle of proportionality, and the main rules of international law like pacta sunt servanda and rebus sic stantibus. So we can therefore speak about two legal orders that remain in a definite relationship. This relationship is shaped by the voluntary will of state. This is very important. And by accepted systematic principles. States allow retain competences to be exercised beyond the national level, while still preserving their independence and sovereignty, expecting greater effectiveness in specific areas that need international cooperation. Importantly, this influence does not primarily result from change in the content of legal norms. So, today, however, we can observe a different phenomenon. There is a growing practical influence of international and European law on areas traditionally reserved to the state. Importantly, this influence, ladies and gentlemen, does not primarily result from changes in the content of legal norms. It results from the changes of interpretation. As a consequence, the scope of these norms may expand without any formal change in the obligation accepted by the state. In this sense, the mechanism operates beyond the direct control of states as subjects of international law. At the same time, this mechanism does not operate in a vacuum. This requires a specific factual context in which it can emerge and develop. Such a context can be found, for example, in the constitutional conflicts. One example of such situation is, of course, the debate of the rule of law in Poland, in which, alongside domestic actors, international and European bodies have also appeared or played a role. And this leads us to the key question: what is the role of these bodies? And how is the case law used within a domestic constitutional dispute? So, ladies and gentlemen, the mechanism I'm referring to can be clearly observed in the case law of the European Court of Human Rights. The starting point here, of course, is Article 6 of the European Convention on Human Rights, which guarantees the right to a fair trial. In its classical understanding, this provision concerns the individual situation of a person and the requirements of a fair judicial process. However, in more recent case law of the Court of Human Rights, such as Xeroflor, Rzeczkowski, Advance Pharma against Poland, the court does not limit itself to assessing an individual violation. It also identifies a problem of a systematic nature, relating to the way judges are appointed and how the relevant bodies function. For example, European Court of Human Rights stated that some Polish courts, for example, Constitutional Court, is not courts in sense of convention standard. What was used, unfortunately, in public debate as a proof that such courts are not true courts within Polish legal order. In my opinion, it was not the good interpretation of the convention standards, and maybe even it was not aim of the European Court of Human Rights. In itself, this is not surprising. On the other side, the problem, maybe another, the European Court of Human Rights control function, we know, allows it to look at the broader contexts, also to find systematic problems. But the real problem arises when the subject of this analysis enters an area that is traditionally reserved to the sovereign decision of the state. In these cases, European Court of Human Rights assumes that if certain elements of the judicial system are linking to the right to the fair trial, then they can be subject to its review. As a result, the convention standard begins to influence matters of a constitutional nature. This direction of interpretation is based on the idea of ensuring the effectiveness of the international law. At the same time, it gives less weight to the principle of conferral, to the state sovereignty, and to constitutional autonomy. This creates a clear tension between these values, in my opinion. On the one hand, there is the need to ensure effective protection of individual rights. That is obvious. On the other hand, there are limits resulting from the nature of international law as a system based on the consent of sovereign states. If states had decided to fully submit competences to international bodies, this would mean, in fact, giving up their sovereignty. However, such a model, in my opinion, has not adopted in history and now. The current system of international law is still based on sovereign states, which retain their core function and transfer competences only to a limited extent. And this is exactly where the first stage of the mechanism appears, the stage of interpretative expansion. Ladies and gentlemen, a similar mechanism can be found and observed in the case law of the Court of Justice of the European Union. The starting point here is the Article 19, paragraph 1 of the Treaty of the European Union, in particular the obligation to ensure effective judicial protection in the fields covered by European Union law. In its classical understanding, ladies and gentlemen, this provision does not give the European Union a general competence to organize the judiciary in member states. The organization of the judicial system still remains part of the national constitutional order, as recognized both truly and expresses verbis by the European Union treaties and the constitutions of the member states, including Poland or Hungary, for example. At the same time, the case law of the Court of Justice of European Union, especially in the cases such as Commission against Poland, concerning the disciplinary regime of judges, Article 19, paragraph 1 of the Treaty of European Union has been interpreted as a basis for assessing national institutional arrangements in the field of the judiciary. In these cases, Court of Justice of European Union assumes that if national courts may apply European Union law, they must meet the standard of effective judicial protection required by European Union law. From a formal perspective, this reasoning is based on the need to ensure the effectiveness of European Union law. However, from a functional perspective, it leads to much broader consequences. It allows Court of Justice of European Union, for example, ladies and gentlemen, to assess elements of the national judicial system, such as the status of judicial bodies, the model of disciplinary responsibility, and guarantees of judicial independence. As a result, a provision that does not clearly establish a competence in this field begins to function as a basis for reviewing it. Once again, we see a tension between the effectiveness of European Union law and the principle of conferral. On the one hand, Court of Justice of European Union emphasizes that European Union law requires independent national courts. On the other hand, the organization of the judiciary has not been transferred to the European Union law as an autonomous competence. So the problem is not whether judicial independence matters. Of course it matters. Of course it is fundamental. The real question here is who has the authority and on what legal basis to define the organizational standards of national judicial system. If the standard of effective judicial protection becomes the basis for assessing every essential feature of the judiciary, in my opinion, Article 19, paragraph 1 of the Treaty of the European Union begins to operate as a quasi-constitutional norm. Not because this follows directly from the treaties, not because this effect is created through interpretation, because it is the effect from interpretation. And this is where we see another example of interpretative expansion. There is no formal amendment of the treaties. There is no explicit transfer of new competences. What changes the practical scope of EU law by interpretation, through the interpretation. As a result, European Union law begins to influence areas that traditionally belong to the core of the constitutional autonomy of the member states. This in turn opens the way to the next stage of the mechanism I'm analyzing. Ladies and gentlemen, we know that these judgments do not remain only part of judicial dialogue. They begin to function in the domestic debate as arguments used to justify specific actions, positions, and decisions in the rule of law debate, dispute. Ladies and gentlemen, at this point we move to the second stage of the mechanism I'm analyzing. As I have shown, the first stage consists of an expensive interpretation of international and European law by international bodies. However, the real impact of this interpretation appears only at the domestic level. What matters is how the state reacts to this interpretation, both in its legal system and in public debate. This reaction, however, is not nature. On the one hand, the state retains the power to decide how to respond to international judgment. But on the other hand, the implementation of the international judgment is a subject of the international supervision, which creates additional pressure to accept a particular interpretation. We can therefore speak of a kind of a double-edged mechanism, where domestic autonomy coexists with international control. In this context, the phenomenon of instrumental use of case law emerge. It is not simply about applying the law, nor about interpreting in the ordinary sense. It is about taking an interpretation developed at the international level and using it at the domestic level as a basis for actual resolving a constitutional dispute. As a result, this interpretation begins to affect areas that have not been formally transferred to the international level and that remains part of the constitutional autonomy of the state. This creates a tension between the principle of conferral and state sovereignty on the one hand and the functional expansion of international law on the other hand. Importantly, this process does not involve a simple reference to a judgment. What happens instead a second reading of the interpretation, ladies and gentlemen, adopted to the needs of a particular dispute. This is important because this interpretation is adopted to the needs of a particular dispute. So, ladies and gentlemen, we may call this a reinterpretation of interpretation. And this is precisely where the main risk appears. In this situation, we are no longer dealing only with the relationship between literal and functional interpretation. Rather, functional interpretation begins to dominate, shaping the practical scope of legal norms. As a consequence, international and European case law becomes part of a process in which interpretation no longer only explains the law, but also begins to shape constitutional outcomes at the domestic level. And it is exactly this moment, the shift from interpretation to its secondary use in resolving disputes, that defines the phenomenon I'm analyzing. Ladies and gentlemen, the mechanism I have described can be observed or could be observed in the debate of the rule of law in Poland. In a situation of constitutional dispute, the case law of the European Court of Human Rights and the Court of Justice of the European Union has started or may start to play an important role in shaping legal argumentation. References to these judgments have appeared or could or may appear in the context of assessing how state institutions function, especially with regard to the status of courts, judges, and the bodies involved in their appointment. However, the key point is that the role of this case law is not limited to its controlled function. Under some certain conditions, it may also operate as a tool used in resolving dispute of constitutional nature. In particular, it may serve as a basis for arguments about the need for institutional changes or about how state bodies should function. In this sense, we can observe the shift in the center of decision-making in matters that belongs to the core function of the state. Importantly, this is not about a formal transfer of competences. Rather, it is about a situation in which the interpretation of international and European law begins to shape the direction of decisions in areas that have not explicitly transferred to the supranational level. This concern is in particular the sphere of constitutional autonomy of a sovereign state connected with its fundamental constitutional functions. We may therefore speak of tendency to reserve this classical relationship in which sovereign state remains the final decision makers in constitutional matters. At the same time, it should be noted that international bodies themselves, through their interpretation, may functionally use the competences and entrusted to them, expanding the practical reach of international European law. In this context, international case law may be used as an instrument, supporting a particular way of resolving a constitutional dispute. This becomes especially important in situations of an ongoing constitutional disputes, conflicts, where such interpretation may provide one side of the dispute with a very strong arguments of its actions. At this point, we can speak of a form of legitimization that is justifying a particular outcome of the dispute by referring to international and European case law. And it is precisely at this stage that the instrumental use of international and European law becomes most visible. Ladies and gentlemen, the phenomenon I've described leads to important consequences of a systematic nature. First, we can observe a growing tension between the principle of effectiveness of international and European law and the principle of conferral, together with a state sovereignty. As a result, interpretation begins to play a role that goes beyond its classical function. As a tool for explaining the meaning of legal norms, it starts to shape the scope of law in areas that have not been explicitly transferred to the supranational level. Second, the role of international and European law, case law, changes. Instead of serving only a mechanism of control, it becomes part of process of legitimizing specific outcomes in dispute of constitutional nature. And third, an important tension appears in the field of legal responsibility. In matters related to the core function of the state, responsibility remains in principle within the sphere of the sovereign state. At the same time, international case law, although it has a real impact on constitutional disputes, does not provide a complete mechanism of assessing individual responsibility for action taken in this area. As a result, we face a situation in which law influences decisions of fundamental constitutional importance without offering a symmetrical system of responsibility for their consequences. This raises a broader question about the limits of interpretation and about the role of international, maybe about the real role of the international and European law in a system based on a sovereign states. Ladies and gentlemen, coming back to the title of my presentation, we can say that the phenomenon I've analyzed reflect a change in the functional rule of international and European law. Under some certain conditions, this law no longer serves only a protective and control function, but begins to operate as an instrument for legitimizing specific actions and directions of decision-making. Importantly, this phenomenon is not limited to constitutional disputes. It also concerns questions of competence, where the interpretation of international and European law leads to an expansion of the practical reach of international bodies. In this sense, we may refer to the phenomenon known as a competence creep. That is, the gradual extension of competences through interpretation. This is negative phenomenon, of course. And in this perspective, the shift from a safeguarding function to a justificatory function should be understood as a form of instrumentalization of international and European law, what is also, in my opinion, negative phenomenon. If we would like to change something, we should go to the norms, not to the interpretation of law. Change the law, treaties, but not instrumentalization by interpretation. But this will be states as a decision-making, not courts, and this is why it's important from the perspective of constitutionalism and international principles. If states will decide like this, okay, but making decision without states and forcing them to acceptance, it's instrumentalization. The first step. Second step is legitimizing national actions based on such international interpretation, and there are still paradoxes in accountability that is not only national in this case, nor not in this case, not international. As a result, we face a situation in which law influences decisions of fundamental and constitutional importance without offering symmetrical system of responsibility for their consequences. So, ladies and gentlemen, I hope that these reflections offer a slightly broader perspective on the relationship between international, European, and domestic law. This analysis shows that the meaning of law does not depend only on its content, but also on how it is interpreted and used in a given constitutional context. But from this perspective, it is important not only to ask what the limits of international and European law are, but also how these limits are shaped in practice. In this sense, the debate taking place in Poland may serve as an important point of reference for a broader reflection on the rule of international and European law in a system based still on sovereign states. But this one point I will describe in my upcoming scientific articles. And to this accent, I would like to say thank you very much for all of you. And I'm so sorry for the extent of my time a little bit. Thank you very much for your attention.